Chief Justice John Roberts has been one of the most controversial and enigmatic justices ever to serve on the U.S. Supreme Court. His rulings have been absolutely head-scratching. From the infamous Obamacare ruling to his unwillingness to weigh in on the 2020 election, the Bush app-appointed justice has been absolutely inconsistent at best and a zero at worst. Well, now, something is finally being done about it. But before we get into that, please like, share, and comment at USA Update. We appreciate your support to try to get common-sense journalism to the American people. Justice John Roberts is now the focus of a lawsuit that is intending to bring some balance and integrity back to the nation's highest court. A pro-Trump legal group founded by White House aide Stephen Miller is suing Supreme Court Justice John Roberts. The lawsuit was filed by America First Legal. It argues that records held by the Roberts U.S. Judicial Conference should be subject to the Freedom of Information Act request or FOIA requests. As a result, AFL cited in its lawsuit recent actions taken by both the Judicial Conference and Administrative Office in 2023 to accommodate requests from Congress to investigate allegations of ethical improprieties by Justices Thomas and Alito, and subsequently to create or adopt an ethics code for justices on the High Court. Now, the lawsuit says, under our constitutional tradition, accommodations with Congress are the province of the executive branch, AFL said, adding, quote, the Judicial Conference and the Administrative Office are therefore executive agencies. It must therefore be overseen by the President, not the courts. Now, this is a big distinction because it looks like they're trying to set up an independent agency within the courts that would have operated like a rogue court in and of itself. Now the lawsuit continues, quote, plaintiffs for AFL argued in their lawsuit that the Judicial Conference's duties are executive functions, and functions they allege must be supervised by executive officers, aka Trump officers, who are appointed and accountable to other executive officers. Now further argued that the courts definitively do not create agencies to exercise functions beyond resolving cases or controversies or administratively supporting those functions. Now, in AFL's view, this is also sufficient to put the Administrative Office of the U.S. Courts, as is overseen by the Judicial Conference, under the executive branch as well. AFL argued that the proposed framework preserves the separation of powers but also keeps the court out of politics. Now that would be a game-changer. Justice Roberts has presided over a court that has been both highly political and highly ineffective. The Supreme Court has cherry-picked cases while letting Americans' constitutional rights and civil liberties get hammered in an onslaught from the radical left. We still don't know who the DOS case leaker was, which led to threats and violent attacks on conservative justices. Kavanaugh and Gorsuch. We have seen selective outrage about Justice Clarence Thomas and taking trips with his friend Heron Crow or his wife's Republican activism. But where was the Robert-led court when it took a blind eye to controversies involving Justice Sonia Sotomayor? For just one example, Justice Sotomayor, her staff pushed universities to purchase her books before she was hosted to speak at public events. Now the public trust in the Supreme Court as a whole is deteriorating. This is not about a problem for conservative justices alone, but we don't need interference or in from these internal enforcement mechanisms that are supposedly aiming to police the court, but wind up pressuring them or even blackmailing. There is no such thing as an independent body, in the true sense of the term. We have to have accountability and leverage on the part of the American people in order to get results that reflect the will of the people. Now we have a U.S. Congress. The bigger problem is that we have justices who are appointed for life, but they don't necessarily serve in so-called good behavior to show fidelity to the U.S. Constitution. We see that with rogue judges around the United States issuing nationwide injunctions at a volume unseen in U.S. history, simply because they see a president who is doing everything within his article. 2 powers to de-weaponize the government and thereby strip away the radical left's captured power base. The radical left clearly has attempted a revolution from above, and the American people have responded by electing a president to carry out a mandate to preserve and protect the Constitution. In the process, the same president is being called authoritarian, all because the duly elected president is using his authority under the executive branch. Now, the problem is that 2 of our branches, the judicial and the legislative, have been absolutely unable to police themselves, let alone check the other branches. So the GOP Congress, if we can even call it being led, has allowed activist judges to trample on the executive branch's powers because its leaders are too cowardly to openly defy the Trump presidency themselves. If Speaker Johnson really supported the American people and this president, he would have already stripped away the jurisdiction of not just these rogue courts, but potentially even the Supreme Court itself, as provided by the Constitution, and for which there is precedent in the early 19th century. And that Constitution also provides for removing judges for failing to serve in good behavior. As such, we have to settle for this lawsuit, which hopes to rein in a politicized Supreme Court and remove leverage from activists who hope to pressure and seize the institution and to install the radical left's agenda. This has been Mike with USA Updates.